Today we're starting off with estates and real property. Estates and real property. This clearly will be a testable topic. I want you to stay focused on it. As we enter into this section right here, good morning. As we enter into this section here, I want you to be aware that a lot of this test is going to have to do with what happens to property, real property, when some life-changing event occurs. When we're talking about real estate, what life-changing events could occur? You could do what? You could sell it. You could move and sell it. Okay, you could sell or buy. You could get married, or you could die. Okay, these are the life-changing events. I want you to notice as we go through what I'm starting now, and certainly a little bit later today, what happens in these life-changing, life-altering events. When we start off talking about estates, it probably has nothing to do with the way you use the word estate in the past. When I think of an estate, I think of a large country estate, or I think of someone dying and passing on an estate. That will come into play, but that's not what we mean. When we use the word estate, what we actually are referring to is any interest in real property. Any interest in real property. That's what the word estate means. Certainly, on the property that I live in today, I own the property, I have an ownership interest, I have an estate in that property. But if any of you currently rent a property, like an apartment or a single family home, and you rent it, you actually have an estate in that property. It's not an ownership estate, it's an estate of possession. But when you think estate, think any interest that you have in real property. That's going to be the first important point. We talked on Monday about the bundle of legal rights. If I own property, then I have the ability to possess it. I have the ability to convey it to another person. I have the ability to control it. We're repeating this here, but you see this chart that you have in your notes? It is a good chart. It makes my head hurt when I study it, though, okay? So what I would like to do as I talk to you today is I would like to talk to you as estates in regards to a hierarchy. So if you don't mind, hey look, that slide is good. But what I'm going to do is I'm going to put it in a little outline format, and I'm going to talk about the estates that way. If you'd like to follow along with the slides, you will see a lot of these terms come up, and you can take your notes accordingly. But what I want to do is talk to you about the greatest estate of ownership in real property and why that is the case. The greatest estates in property are known as freehold estates. The top of the hierarchy, the top of the totem pole, are going to be the freehold estates. That's okay. It's supposed to be silent. Are you waiting on a kidney? Is that why that goes on? Huh? Is something important? Okay, because if you are, I'll let it pass. But after there you go, you reminded everyone else. So I'll assume that that's why you left it on. To remind others, turn off your electronic devices. Thank you very much. Freehold estates, when you see the word freehold, think ownership. I have an estate in the property, I actually own the property. My guess is that the book probably says something to this effect, estates of at least a lifetime, which is true, which is absolutely true, but it's just easier for me to think of freehold estates are ones that you actually own. And if you actually own an estate, there's a really good chance that you have a legal document that says you own it. What is that legal document most likely known as? A deed. A deed. In chapter 2, I heard someone use the word title, but when we talk about title in real estate, it just means ownership. The deed is the manifestation of that ownership. It's the physical document, okay, the deed. Very good. All right, freehold estates are at the top of the list. Now let's start breaking down the freehold estates. Within the freehold estates, there are going to be several names for other estates. For example, the fee simple absolute. And here's what you're writing down on the fee simple absolute. The fee simple absolute is the greatest estate of ownership in real property. Write it down with inflection. The greatest estate of ownership in real property. You say, what makes it great? Here's what makes it great. Not only do you own it, But you have the ability to leave it to whom? Your heirs, technically anyone you want to. Just so you know, you don't have to leave your property to your heirs. You can screw your heirs if you want to. You can leave it to the SPCA if that's what you want to do. But if it is a fee estate, you own it, and then you can leave it to whoever you want to. Do you see the word fee in regards to fee simple absolute?
Yes.
I want you to circle the word fee, and I want you to make a note on that. The word fee, when talking about estates, it denotes inheritability. The word fee denotes inheritability. It means you can leave it to your heirs or to others if you choose. Now watch this. In theory, if you don't sell a fee simple absolute, if you don't sell it, in theory, how long do you own it?
Forever.
Forever. Yeah, a lot of people say, well, you own it for life. Actually, you own it forever. Because in theory, what happens is you own it for your life, and then you can do what with it when you die? You pass it on to someone else. So in theory, you own fee simple absolute forever. The greatest estate of ownership in real property. You got that one? Feel good about that? Okay, you should. Now let me tell you the only trick that might come up for test purposes on the fee simple absolute. I own my property in fee simple absolute. For those of you who own property, I'm going to take a shot in the dark and guess most of you own your property in fee simple absolute as well. When we talk about this, we're talking about the longevity of the title. We're not talking about the quality of the title. Do any of you have any encumbrances? I know we haven't talked about that word yet, but do any of you have any burdens? Do any of you have a mortgage?
Yes.
Do any of you have taxes on your property?
Yes.
Yeah. So when we talk about the fee simple absolute, we're talking about the longevity of the title. It could be eat up like crazy with liens and mortgages and stuff like that, but it's still fee simple absolute. Do you understand what I'm saying?
Yes.
Perfect, perfect. Okay. That's easy. You're going to get right on the exam. I hope you get that question. Now you only need 83 more points. Now having said that, that's too easy. That's too easy. Let me give you something to compare to so you'll understand what I mean by quality of title. The next category of estates that we're going to talk about is known as the defeasible fee estates. Now you notice that I'm coming down the totem pole a little bit here. In other words, defeasible fee estates are less desirable. Defeasible fee estates. Now here's what I want you to write down. In regards to defeasible fee estates, there is a condition, and please underline the word condition. There's a condition which, if broken, could result in reversion. And underline reversion, obviously deriving from reverse, okay? There is a condition which, if broken, could result in reversion. Got it, Sandy? You comfortable over there today? Is everybody else comfortable? Good. If not, tell Sandy. She's in charge of the thermostat. Okay, now let me give you an example on this. Do you remember me talking about level 1, level 2, level 3? Okay, you are tempted to treat this as if it were a legal topic like it's law school. Do not. This is actually a level 1 topic. If you understand what I'm getting ready to talk about, you are done with the defeasible fee estates. Now, is a defeasible fee estate inheritable? Yes. Why do you say yes? What word does it have in it?
Fee.
Fee. Do you understand why it's less desirable than the fee simple absolute? Because it has a condition in it. Let me give you an example of that condition. I grew up in Kinston, North Carolina. I have clearly moved away from Kinston. It's a nice place to be from. I'm not going back. Let's say that I inherited some land in Kinston, 40 acres of land in Kinston. It's nice property. It's in a decent location. And so I inherited it. I don't owe any money on it, but I'm never going to use it, right? So I get to thinking about what should I do with that land? Well, I think about this. The church that my family grew up in, we were in it for generations, okay? They are looking to expand. They need land. I have land. I ain't pay anything for it. I feel guilty about even having it. Wouldn't it be a beautiful thing if I just took that land and did what? Donated it, gave it to the church. Okay? If I titled the land from me to the church, who now owns that property? The church does, the entity of the church, okay? But here's the deal. When I donated that land, when I gave that land to them, I wanted them to use it for what purposes? For church purposes. So I put a condition in the deed that says this: as long as you use it for church purposes, it will be yours. Okay? So we give the property to the church. They have plans for putting a new building there, an educational building, or whatever they plan on doing as church purposes. Okay? However, before they get very long in their plan, after I've conveyed the property to them, here's what happens. Walmart comes along, and Walmart is looking to put a super center in Kinston. All right? And so Walmart, I'm not sure if you're aware of this, but they have more money than God. So what happens is Walmart comes in and makes a crazy offer for that 40 acres of land. Can the church sell Walmart that property?
No.
No, because if they do, it's going to what? Revert back. It's going to reversion back to the grantor, which is me. Now, how long will the church own this property if they use it for church purposes? Forever. They're going to own it forever because it's a fee estate. Defeasible fee estates have a condition which, if broken, could result in reversion. End of story. Congratulations. All right? Questions or comments on that? However, if you do have a question on that, I would like for you to keep it relatively simple. You okay on that? Now, if we really want to be difficult for test purposes, we can ramp this question up one level. All right? I don't know that we're inclined to or not, but we could. There are a couple of common types of defeasible fee estates. These are actually in your book, your textbook, if you'd like to read more about them. And again, please ignore the temptation to go too deep into this, but I do want you to know the difference between the two types of defeasible fee estates. Okay? One of them is known as a fee simple determinable. It is worth writing in your notes. But notice how I'm going to indent here because it's a type of defeasible fee estate. Fee simple determinable and then the other one is a fee simple subject to a condition subsequent. And if somebody finds the page number in the book, if you want to just call out the page number. So, is it 29? Are both of these words probably highlighted on page 29? Okay.
Is the chart? It's 30.
29, 30, somewhere along in there. Okay. Now, let me tell you the significance of these. These are both types of defeasible fee estates. They have a condition, blah, blah, blah. You okay with that? Why did I mention them to you? Well, they have a little different legal concept to them. And here's the only thing I want you to know. You can study it all you want to, but here's the only thing I want you to know in regards to these two types of defeasible estates. The fee simple determinable, what you're writing in your notes, will automatically terminate if the condition is broken. The key word you're underlining is automatically terminate. In a fee simple determinable, it will automatically terminate if the condition is broken. The example I gave you with the church was a fee simple determinable. Automatic reversion, if it's broken, you okay with that? That was a key point. All right, well, let me talk to you about the condition subsequent. In the condition subsequent, the key point that you would need to know on this is that if the condition is broken, the grantor would have to step in and exercise their legal rights. So in other words, you broke the condition, I'm going to sue you to get my property back. Okay? So in a condition subsequent, notice it was not automatic, right? It didn't automatically revert. I had to step in and exercise my legal rights. I had to file a lawsuit to get my property back. You with me, Olga? Okay, good. Go. Say again, I'm sorry? The grantor has to step in and exercise their legal rights. In other words, they have to file a lawsuit to get their property. Say again, I'm sorry?
I said the first one is automatic, the second one is necessary action.
That's exactly right, and that is as brief and specific as you need to be. I don't know if you need an example of the second one. The determinable, a great example to use is my situation with the church. The conditions subsequent, you may have heard about these before and just never noticed what it was. Have you ever heard of a business that was sold or a piece of property that was sold subject to the fact that you couldn't sell intoxicating liquors on the property? Sometimes you will see that grantors, the sellers, will put this information in there. Yeah, you can use it, but you can't do this particular thing in the property. That's usually when you see a condition subsequent. If you do that thing, then I'm going to file a lawsuit and I'm going to get my property back. Now the temptation here is to say, well, what about money? What if they pay for the property? What's going to happen at this point? Seek legal advice if you get to that point. I will tell you, 99% of the ones you see in your career are going to be fee simple absolutes. The feasible fee estates outside of this exam, you are probably never going to see this again. Although, I did see an interesting listing one time on Highway 70. There was a church that was for sale. It was literally a church that was for sale. Out on the marquee, instead of saying Jesus saves, it said for sale. Okay? So anyway, I'm riding by there and I'm keeping my eye on what's going to happen with this particular property. It's a decent location on Highway 70. Eventually, the for sale sign goes down. So I'm assuming it's under contract. And it's like that for a period of time. A little bit later, it comes back on the market. Here's what the sign says now. For sale, church purposes only. What do you suppose someone discovered when they looked at the deed? Years ago, it probably had a condition in it that required it to be used for that particular purpose. That's probably about the only example I've actually seen. Obviously, I read a lot of textbooks and stuff. They give other examples. That's the only one I've ever actually seen in my real estate career. Okay? Now, how did we get here? We're talking about freehold estates that are inheritable. Is that freehold? Does the church own it? Yeah. Is it inheritable? Well, an entity doesn't die. But if I had given it to a person under these conditions, yes, they can leave it to their heirs as long as they don't do what? Break the condition. As long as they don't break the condition. You okay with that? You're not going to go to law school on me on this, right? Level 1. But please study it exactly as I said it. Now, if you think that was hard to understand, wait till you see this next one. This one's fun. Fun to talk about. I'm guessing you'll never see one of these in your real estate career. I'm going to write it at the bottom, but then I'm going to erase the board because I need some room to draw this out. A life estate. A life estate per Otrovie. Life estate per Otrovie. I'm sorry, I got too low on the board. You might not be able to see it from the chair. Life estate per Otrovie. Anybody? I don't know if that's how you say it or not. Anybody in here speak French? All right, and go for it. A life estate. That's what I said. I speak Southern French. Per Otrovie. That's what it is. Now, and while you're on a roll, what does per Otrovie mean?
It means pure other life.
For the life of another. Per Otrovie means for the life of another. You own property for the life of another. That's literally what per Otrovie means. Okay? Once you write it down, if you don't mind, I'm going to erase this board and I'm going to draw this out for you. Okay. You own property for the life of another. If A owns a property and grants it to B, now you keep hearing me use the word grant. You may hear me use the word convey. The reason I don't use the word A sells the property to someone is you do understand that property doesn't always have to be sold. It could be given. So we use words like grant and convey in the class. Those words will be important a little bit later. But if A grants the property to B, who owns the property? B now owns the property. A put an interesting condition in the deed. He put an interesting condition in the deed. B, you own the property as long as C is alive. B owns the property for the life of C. Isn't that the strangest thing you've ever seen? It's pretty strange. Pretty strange. If you see one of these in a deed that you're taking a listing on, please seek legal advice. All right? Now, let's watch this. A to B for the life of C, and then D. So how long does B own this property?
As long as C is alive.
As long as C is alive. The minute that C dies, who owns this property? D. Per V. For the life of another. I started to say, does this make sense? It doesn't. Okay, I mean, in contemporary estate planning and stuff, you rarely are going to see these. But having said that, doesn't mean we can't test you on it. But do you want to know how we're going to test you on it? Watch this. No per V has ever been created thinking that B was going to do what before C?
Die.
Every time this has been created, I'm sure they thought that C was going to die before B. But what happens today if B pulls out of his driveway and bam, gets hit by a truck? Okay, he's dead. So the question becomes, if B predeceases C, who's the property going to go to? Go ahead and get all your wrong answers out of the way, and then I'll tell you the right answer.
Is that anything?
Wrong. Wrong. Wrong.
How about the
It's going to go to B's heirs because it is an inheritable estate. Remember how we got here? We were talking about freehold estates. Does B own it? Yeah. Is it inheritable? You can even write this down in your notes if you want to. Freakishly enough, this is inheritable. It's freakishly inheritable. No one ever thought B was going to die before C. But when B dies, it has to go somewhere. And it's going to go to B's heirs. It's not going to go back to A. A doesn't own the property. He gave it to B. It's not going to go to C. C is simply a measuring life. Just serves as a clock. D will not get it until C dies. It's an inheritable estate, so when B dies, it will go to his heirs. At the end of the day, that is the factoid that I need you to know about this. In a life estate per V, is it freehold? Yeah. Is it inheritable? Freakishly inheritable. Yes. Yes, ma'am.
But the heir only gets it until wait.
The heirs will own it as long as C is alive,
Okay.
and the minute that C dies, bang, it is now D. C will never own this property. C will never own this property. Now, I'm going to tell you a story, and I don't want you to read too much into the story. But in fairness, some people say, I don't get it, and it's fair not to get it. The reason that I hesitate sometimes to tell this story is he gets into civil, C-I-V-I-L, issues, and we don't discuss civil issues in this class. We're talking about the real property consequences of this. But in fairness to you, you say, how might this happen? So here's the deal. A and C are an elderly married couple, okay? A is going to die soon. His wife has diminished legal capacity. His wife has a son from a previous marriage. A didn't care much for him, but he takes good care of mom. All right? So A says, look, when we married, you moved into my property. So here's what I want to happen. At my death, I want it to go to B, your son. He will own it as long as you live. But upon his death, I don't want him to get it because he's a sorry jerk. All right? I want it to go to someone else. Maybe his kids from a previous marriage. Maybe the SPCA. Who knows? But A has already chosen who it's going to go to at C's death. You see why someone might do this? There are better ways to do this in contemporary estate planning. But that is a possibility. Testable point. Is it freehold? Yeah. Is it inheritable? Previously enough. You got it? Life estate per V. You are not going to see this in the field, and if you do, you're calling an attorney. Questions or comments on that? I don't really mean it. Let's move on to something else that makes sense. Okay. I'd like to pause for effect right here. Okay, that was me pausing for effect. We are getting ready to cross a line. The line, the important line that we're getting ready to cross is, we're still talking about freehold estates, but we're now going to talk about freehold estates that are not inheritable. Freehold estates that are not inheritable. Are you with me? Okay? Fortunately, this is a category of one. Okay, if you ever hear the word life estate used generically, in other words, the life estate per OHRV is always called a life estate per OHRV. If you ever hear the word life estate used, it's actually talking about what we're getting ready to talk about now. Sometimes referred to as a conventional or traditional life estate. You actually will see some of these, either in the field or maybe within your family. I want you to notice the difference between this and the per OHRV, and that's going to be the important part. In this case, A conveys the property to B. If A conveys the property to B, who now owns it?
B.
B. But A put a condition in there, said A to B for life. How long does B own it?
Forever.
As long as B is breathing. The minute B stops breathing, they don't own it any longer. A to B for life, and then C. Who chose C? A. At the time that A created the deed, A said, B, you own it as long as you're alive, and then it's going to go to C. So let me ask you this question. Is it going to go to B's heirs when B dies?
No.
No. Do you see why that's different from the estates we previously talked about? It is a life estate, B owns it, but at their death they cannot determine who it's going to go to. It has already been determined who that property is going to go to, okay? Now, I tell you that you may see some of these in the field in your life. My dad's estate, when he passed, my dad was married to my stepmother. They both had families of their own before they were married. After they married, they lived in the house that I grew up in. At Dad's death, he wanted her taken care of, right? So you own this property as long as you're alive. But at her death, he doesn't want it to go to her kids. Nothing against her kids, but this is the house that we grew up in. So A to B for her life, and then who do you think C was? Yeah, Dad's kids, not her kids, okay? So she couldn't pick her heirs. Dad had already picked who it was going to go to. And that's why you see this a lot with mixed marriages and stuff like that. People have previous marriages. It's not horribly uncommon to see these.
This one's just called life estate.
Just called a life estate. I may refer to it as a conventional or traditional life estate. Okay? And tell me your name again. Jim.
Yeah.
Jim. Do you understand, Jim, that it is freehold and it is not inherited? Bam! You are there. You are there.
C dies.
Take it up.
C dies.
Okay, Victor's question is, we're here now. C now owns the property. How does C hold title to the property?
He's still forever.
Fee simple absolute. Fee simple absolute. There are no conditions once C gets the property. So when C dies, who's it going to go to?
His heirs.
C's heirs or whoever they left it to in a will. Very good, very good. Okay, yes?
Is this red? Should I mark it red?
It's complex. It's not a level 3 topic. You should study this like Sesame Street, okay? Why are these estates different? That's where the test questions come in, okay? Let's throw in a little bit of vocabulary, if you don't mind, on the life estate. C goes by a specific name. C is what is known as a remainder man. Remainder man. They're getting the remainder of the estate. Does that make sense? Remainder man. Sounds like a real estate superhero, doesn't it? Remainder man. That's not meant to be sexist, by the way. It's always called remainder man, whether it's male, female, or the SPCA. Okay. The other thing that you might see, now watch this. See if you can figure this one out, and then I'll give you the answer. What if A simply said this? A to B for life, What would happen if B died under this circumstance? A to B for life. Who's it going to go to? It goes back to A or A's heirs, whoever's standing in A's shoes at the time of B's death. This is what is known as a reversioner. You hear that word again, reversioner? It just simply reverts back to A if there is no remainder interest. Yeah?
Is that the same as C dies before B?
If C dies before B, actually C's heirs would have been in line. The remainder man's heirs would have been in line. Okay? Did you get the words remainder man and reversioner? Do you understand how they apply to the life estate? Okay, good. Now, I don't, was it Brett?
Right.
Brett, okay. I don't know if it makes sense to you or not, but if they could anticipate that one of the remainder interests are going to die, you can actually have subsequent life estates. You could say A to B, then C, then, you could have it set up that way, but if not, it would go to C's heirs. Okay? Let's go back to A to B for life and then C, just real quickly. See if you can figure this one out. A to B for life and then C. A to B for life and then C. Okay? Does C have any interest in this property while B is alive? They kind of do. They kind of do. It's referred to as a future interest. Because unless B beats the odds, B will eventually what? Die. Okay? And at that point, C, or whoever is in C's shoes, will ultimately get the property. So you actually refer to that as a future interest. It does have value. Would you be interested in buying, watch this. Well, let me set it up first. Can B, as long as B is alive, can B sell their interest in the property? Can they sell the property?
Yeah.
Can a life tenant sell the property?
If they have C's permission. Maybe.
Wait a minute, I was saying no to C's permission. They don't need C's permission. Okay, who said yes?
If he can sell it.
Said yes in the back row? Would you like to explain your answer? The question on the floor is, can B, as long as they're alive, legally sell their interest? Can you defend your answer?
I would say because they own it, as long as they're alive, they have full ownership.
They have full ownership, and what did we say on day one? If you own real property, you have the right to disposition, which means that you can sell it. But Jonathan, for the win, if you own real property, what is it that you can sell? Only that which you own. Okay? If B is 98 years old with a cough and walks with a limp, how much is that estate worth? I don't know. Just because you have the right to sell it doesn't mean that there is a market for it. Okay? So B does have it. She owns it. She has the right to sell it. Does that make sense? Can't promise you there'll be a market for it. On the other hand, how about C? Would you buy C's interest? Happens all the time. Happens all the time. Developers will buy C's interest because they're trying to get their hands on this piece of land. And so they'll buy the future interest, knowing that when this person passes, now they can own and develop the land. Go ahead, Ed.
Okay, well, so this is titled a non-inheritable freehold. But
Correct.
It does hit a point where it becomes inheritable.
Not this doesn't. Now, once B dies, the life estate is over.
Oh.
Okay? Once C owns it, they now have a fee simple absolute. Okay?
So that's
And the
not-
fee simple absolute would be